Again, everybody, this is attorney Mark Brunner, and thank you so much for joining me again here today on Talking Texas Law. Today, let's discuss a small but very powerful and impactful part of the Texas Penal Code. It really only has just a little bit of text, but it has great impact potentially on people who are charged with multiple offenses. Section 1245 of the Texas Penal Code essentially states that a person may, with the consent of the prosecuting attorney, admit during sentencing on one of their charged cases, admit to one or more unadjudicated cases that they may be facing in that county or perhaps even other counties, and requesting that the sentencing court to, quote, take into account those other unadjudicated cases in determining the sentence for that first case that they have pled guilty to. So again, basically saying, Judge, I'm admitting to multiple cases on this case or these cases over here. I'm asking you to be sentenced on, but I want you during the sentence on that to take into account everything else I've done and admitted to. So when I get sentenced to these cases, those other cases will then be, under Section 1245, dismissed. Again, a very powerful way to take care of multiple charges all at the same time without having to get a conviction on multiple charges. So again, let's clarify this on using a real-world example. Let's say someone has been charged with, say, a hot check. So they've got one case in one county, and then later, let's say they go out and commit a new offense. 2 or 3 weeks later, they pick up a DWI, they don't pull over fast enough, they try to run from the police. So now it's a DWI, a evading arrest, and then it's also a hot check. So we've got 3 cases all in the same county. How can 1245 impact that prosecution? Well, under Section 1245, with the permission of that prosecutor, the defense attorney and the defendant would work out a way to, let's say, for example, plea on just one of those cases. Let's say the DWI. That defendant, he or she would come to court, plead to the DWI, admit guilt to the hot check that happened earlier, admit guilt to the evading arrest that happened at the same time, and then ask that court under Section 1245, the DWI court, to, yes, sentence me on that case, but to take into consideration these other 2 cases that I have pled guilty to, that I have admitted my guilt to, that have been unadjudicated. So that at that time, if the judge accepts the deal, takes those other cases into consideration, that person will be sentenced for DWI, and those other 2 cases will be dismissed. Again, very powerful. That can be whether those cases are at the same level or higher. It really doesn't matter. Let's say the DWI was a misdemeanor, yet the evading was a felony. It could work like that, or vice versa. Again, they don't have to all be at the same time. In fact, they don't even have to be in the same county. Let's say that hot check case happened in Bell County, but the driving while intoxicated case and the evading happened, let's say, in Travis County. With the permission of the prosecutor up in Bell County, the cases in Travis County could be 1245, or part of that deal would all be worked out. Again, you have to notify all the different agencies that would be involved if it is a 1245 that's essentially going to cross county lines or cross judicial district lines. But it is available. So again, a powerful way for a defendant to get rid of multiple cases resulting in dismissals, perhaps only for 1 or 2 convictions instead of multiple convictions. Well, what are some limitations to 1245? It's not perfect. A dismissal obtained via a 1245 plea cannot be expunged. It is not eligible for expunction. So yes, it's a dismissal. It's not a conviction. It will be entered into the Criminal Justice Index as a dismissal, but it is not something that will be eligible for an expunction. So it will remain on your record as an arrest, as a prosecution, and it will show that it was dismissed, yes, no conviction, but it will still stay there pretty much forever. Also, you can't 1245 into a deferred adjudication. It has to be a conviction. So it can't be that, let's say, I'm going to take a felony deferred on the evasion and then get my misdemeanor dismissed for the DWI and get my misdemeanor dismissed for a hot check via 1245. The actual case that's being adjudicated, the one that you're getting the conviction for, must be a conviction. It cannot be a deferred adjudication probation. It has to be either jail sentence, prison sentence, or what's called a straight or regular probation, not deferred. With all that, also there's just the subtle question of perhaps opening yourself up to some sort of civil liability. Let's say there's an assault charge along with another case. The other case is the one that gets sentenced. Let's say it's a drug case and an assault case. Drug case gets conviction. The assault case gets 1245. However, the defendant has admitted guilt to that assault case. Well, that may open up that defendant for some sort of civil liability, because it is, even though it wasn't a conviction, admitting your guilt under 1245 to that, let's say, assault, perhaps would open you up civilly. You can't be in criminal court and saying, yes, I admit I'm guilty, I assaulted this person, and then later in civil court turn around and say, hey, I didn't do it. I wasn't convicted. Again, you would have entered a judicial confession to that offense saying that you're guilty, even if the judge did not find you guilty. So again, there are some nuances to Section 1245, yet it still remains a very powerful means available to a defendant who's charged with multiple cases, perhaps even in multiple counties, to try to resolve things in a nice, smaller package of sanctions than having to take a hit to their record for each case that they have been charged with. So again, that's Section 1245 of the Texas Penal Code. As always, this video is being offered for educational and informational purposes only. It's not to be construed as giving exact legal advice and does not take place of a true legal consultation. And unless you are already a contracted client of mine, I'm not your lawyer. This has been Attorney Mark Brunner, and thank you so much for joining me here today on Talking Texas Law. I'll see y'all next time. Thank you.